My name is Vishnu Gopal TV. I am a legal intern at LEXIS and Company. I am from Cooperative School of Law, Kerala. I am a third year student pursuing BBA LLB Arts. So today's topic for this video is tort of nuisance. So the purpose of this video is to speak about the tort of nuisance. So we know that in simple words, the nuisance means unlawful interference into a person's use or enjoyment of land. For example, noise, vibrations, heat, etc. So in nuisance, there is an interference with the use of enjoyment of land. So when we compare trespass with nuisance, we can see that in nuisance the interference is indirect, but in case of this trespass, it is a direct interference. So when we look into the types of nuisance, we can see that the nuisance are mainly of two types, that is public nuisance and private nuisance. So the main difference between this public nuisance and private nuisance is that public nuisance is a crime, whereas the private nuisance, it is a civil wrong. So in case of this public nuisance, it is really an interference into the right of public, and such a thing is considered as an offense which is punishable under the criminal law. So for example, the obstructing the way by digging a pit in a public highway, it is a public offense, as we know, and will cause inconvenience to many people that goes through that way. So therefore, if each of the person who is being affected, or each of the person who is being affected with such an inconvenience, if brought independent suits, there will be thousands of suits. So therefore, in order to avoid that such a thing is considered as a crime, in order to avoid the multiplicity of suit, and is punishable under the criminal law. So in order to bring a civil action for such a public nuisance is possible only if the particular person has suffered some special damage from such an act. So private nuisance have to be also analyzed. So in order to constitute private nuisance, certain essentials must have been satisfied. So such essentials are unreasonable interference, interference with the use of enjoyment of land, and damage. So unreasonable interference means interference which will cause damage to the plaintiff's property or had brought discomfort for the plaintiff, and such interference will be caused unreasonably. So it is true that that every person should put some sort of noise, or should some sort of noise, smells, vibrations, etc. So because it is required for all members of the society to enjoy their own rights. So interference with the use of enjoyment of land is the next important essential to constitute the nuisance. So interference may either cause injury to the property itself, or injury to the comfort or health of the occupants of certain property. So here in this case of this nuisance, the next essential needed to constitute this nuisance is damage. So in order to prove this nuisance, actual damage has to be proved. So in case of public nuisance, the action which is being under tort can be taken only if special damage has been proved. And in private nuisance also, damage is an important element or essential to be proved to take legal action for nuisance. So the main defenses which is been available and is accepted by the courts against nuisance are prescriptive right to commit nuisance, and as well as the statutory authority. So the prescriptive right to commit nuisance means the right to do an act which would be otherwise a nuisance may be acquired by prescription. So in case of statutory authority, it means an act under the authority of a state is a complete defense. So therefore we have analyzed regarding the nuisance, the types of nuisance, essentials to constitute the nuisance, and the main defenses which are available. So that's all about the topic. So you can like, you can subscribe and comment on my video, and do like and subscribe our YouTube channel Lexcliq. So please give me a feedback regarding this video, and if you have any questions relating to this video, you may please mention that question in the comment box, and I will be replying as soon as possible. And this video does not solicit any types of promotion or advertisement as per the guidelines of Bar Council of India, and the sole purpose of this video is for educational purposes only. So by saying these words, I am concluding. Thank you.